So this presentation is going to be about the judiciary in the United Kingdom. So when we're talking about judiciary, we're talking about judges. And it's important to remember the hierarchy of the courts, because the higher up the judge sits in that hierarchy, the more senior they are. And the judges at the top of the hierarchy, Supreme Court, Court of Appeal, make decisions which are binding on the courts below them. In order to fully understand the role of judges, you also need to understand judicial precedent and statutory interpretation. These things all work together. So if you're not familiar with those, then you need to watch the 3 videos in tandem. So there are different types of judges. We have superior judges and inferior judges. The head of the judiciary is the Lord Chief Justice, and the superior judges are justices of the Supreme Court, Lord Justices of Appeal, and High Court judges, which are known as puisne judges. So that word that you can see there is pronounced puisne. Inferior judges are circuit judges in the Crown and County Court, recorders, which are part-time judges, district judges who sit in the small claims and county court, district judges in the magistrates court, and judges who sit in tribunals. All judges in appeal courts hear appeals from the court below. The reasons given can form precedent which can be followed in later cases. In the civil courts, they sit alone to decide the facts of cases, make decisions on who wins the case and the damages awarded, so who is liable. In the criminal courts, in the Crown Court, they sit with the jury and decide on the law if guilty, and then decides the sentences. And in the magistrates court, they sit alone and decides on the facts and the law and whether somebody is guilty or not guilty, and give the sentences. So the 2 boxes at the bottom there, those are courts of first instance, both in the civil courts and the criminal courts. So we're going to have a look at the different types of judges, and we're going to work our way down the hierarchy. So the Lords of Appeal in ordinary, or the Law Lords, or now the Justices of the Supreme Court, they hear about 100 cases per year, both civil and criminal, although mostly civil. The cases must involve a point of law, and they have to sit in an uneven panel so that they don't have a split decision. So a minimum of 3, so you could have a 2-1 decision. The more important the case, the more judges sit to hear it. So some of the appeals over the Brexit negotiations, all 11 justices of the Supreme Court sat, and they set precedent which has to be followed by all courts below. So you can see in that picture, those are the justices of the Supreme Court, and in the middle you have Lady Hale, who is the head. The next set of judges down the hierarchy are Lord Justices of Appeal. Clues in the name, they only do appeals, but they do both civil and criminal work. And they do far more work than the Supreme Court. They usually sit as a panel of 3, but for more important cases they can sit as a panel of 5. And they set precedents for courts below them, but they have to follow the precedents of the Supreme Court. The head of the Court of Appeal Civil Division is called the Master of the Rolls, and the Lord Chief Justice is the head of the judiciary in England and Wales and is the president of the Criminal Division of the Court of Appeal. There will be a test in a bit, so you need to remember what these different people's titles are. So moving down again, and you can see a picture of a High Court judge. They mainly try first instance civil cases, and they do this sitting alone. They hear the evidence, they decide which law to apply, they choose who is liable, so the winning party, and they can set damages and any other remedies. They can hear first instance criminal cases in the Crown Court, and they can sit with a jury. They hear some appeals cases, so usually civil cases from the County Court, and they can hear criminal appeals on a point of law in the Queen's Bench Division of the High Court. So these are circuit judges. They sit in the County Court to hear civil cases. They sit in the Crown Court to hear criminal cases with a jury. and they deal with matters of law and sentencing in the Crown Court or remedies in the County Court. And if they are in the Crown Court, then it's the jury that decides on guilt and they just decide on the sentence. So recorders are part-time sitting posts for up to 20 days a year, and the lawyer spends the rest of their time continuing their private practice, or they could be a legal academic. They're appointed for 5 years, and they're mainly used in the Crown Court to try criminal cases, and occasionally they're used to try civil cases in the County Court. So recorders is very much a step between being a full-time lawyer, whether you're a practicing lawyer or an academic lawyer, and being a judge. So it's an opportunity to try out the role, make sure that it's something that you want to do and you're able to do before moving across permanently. So now we're on to district judges. In the County Court, they hear small claims and fast-track cases, and in the Magistrates' Court, they hear criminal cases instead of magistrates, so they sit on their own as an alternative. And looking at the qualification in terms of the individual courts, to be a judge in the Supreme Court, which are also known as the Lords of Appeal in Ordinary, or previously the Law Lords, you need a 15 years Supreme Court qualification or have held high judicial office. So to sit in the High Court, to be a High Court judge, you need a 10-year certificate in the Crown Court. High Court judges, 10-year Supreme Court So, I said that there would be a test, and here it is. What I would like you to do is you may have to pause the video so you can have some thinking time. So, what type of judge am I? I'm the head of the Judiciary in England and Wales, the President of the Criminal Division of the Court of Appeal. Who am I? Well, I am indeed the Lord Chief Justice. Next up, who am I? I'm the head of the Court of Appeal, Civil Division. This is not an actual picture of them, just by the way. They are the Master of the Roll. I sit and hear cases of first instance in both. I'm a High Court judge. Who am I? I'm a part-time judge who hears cases in both the Crown Court and the County Court. I'm a recorder. Who am I? I'm a full-time legally qualified professional in the Magistrates' Court. A district judge in the Magistrates' Court. Who am I? I hear cases in both the Crown Court and the County Court. I'm a circuit judge. Who am I? I sit in the Court of Appeal to hear cases. Lord Justice of Appeal. Who am I? I hear appeal cases in both civil and criminal law. The cases I hear establish important precedents. I am the final point of appeal within the country. Who am I? Lord of Appeal in Ordinary, a Law Lord or a Justice of the Supreme Court. So, Joseph Chamberlain people, you have some questions on page 25 and page 26 of your booklet. Everybody else, these are the questions. Pause the video here, do a bit of research, have a look in your textbook, and I'd like you to describe the process of being selected to become a judge, suggest reasons that the process was modified, outline some of the skills and characteristics that people need to be selected as a judge. What do you think the most important skills needed by a judge are? And finally, would you make a good judge and why? So pause the video here and have a look at the answers to those questions, please. So, in answer to the first one, describe the process of being selected to become a judge. So, the Lord Chancellor selected prior to 2006 the people who were going to be judges. However, as a result of criticism in 1994, junior posts are now advertised and interviewed for the first time, with a panel of 3 making a recommendation to the Lord Chancellor. Now, when we say recommendation, it's extremely unlikely that that wouldn't be taken forward. So applicants are also required to attend an assessment day, and so suggest reasons why the process was modified. Well, this comes from the Peach report, made the comment that prior to the reforms outlined before, people didn't apply for a job as a judge. They were selected, so they were invited to put themselves forward by the Lord Chancellor, and the Lord Chancellor's civil servants had gathered files about potential judges and kept candidates under constant review. And this is because the senior jobs were limited to practicing barristers. And at that point, there was only about 1,000 people eligible. So it was possible to do it. But as the size of the bar increased, it was no longer possible to keep tabs on everybody. So it was no longer seen as suitable that this is the way that it was done. So the Peach reforms. These are the reforms that were suggested. So all vacancies advertised with job descriptions and person specifications, just like any other job. No longer was it the case that you had to be spotted. It was now you put in your application form and you were judged on that. The Lord Chancellor's Department published the key determinants affecting an applicant's chances of success, so you would have some idea before you applied whether you're likely to be successful. Detailed feedback based on the selection criteria offered to all unsuccessful candidates. The requirement for High Court judges to spend up to 3 months of the year away from home was removed because it was seen as discriminating against females who were likely, and again this is not my opinion, this is the reasons given in the Peach reports, females were more likely to be doing childcare, so would be less likely to be able to spend time away. If the consultation process is to continue, training should be given to those consulted, and assessment selection should be adopted, which it was, and all judicial appointments should be subject to appraisal and evaluation. So, outline some of the skills and characteristics people need to be selected as a judge. So these are split into 5 individual areas, and in an exam question you'd need to name each area and give some analysis about what is included. So first of all, they need intellectual capacity, which is expertise in your chosen area, the ability to quickly absorb and analyse information, appropriate knowledge of the law and its underlying principles, or the ability to acquire this where necessary. So you need to be smart and you need to be able to learn quickly. You need personal qualities, integrity and the independence of mind, so you're not overly swayed by highly influential people and you're able to make your own mind up. Sound judgment, decisiveness. You can't have a judge agonising over a decision for months and months. They need to be able to make their mind up quite quickly. Objectivity, to be able to see several sides of an argument. Ability and willingness to learn and develop professionally, so not stuck in their ways. Thirdly, they need an ability to understand and deal fairly. So treating everyone with respect and sensitivity, whatever their background, and a willingness to listen with patience and courtesy. They also need authority and good communication skills to be able to explain the procedure and any decisions reached clearly and succinctly to all those involved. Remember that a judge is going to be talking to people from all different walks of life, not just lawyers. So everybody needs to be able to understand them. So being able to speak in such a way that anybody would be able to access some of the very complicated things that they're saying can be a real challenge. They need to be able to inspire respect and confidence and maintain authority even if they are challenged. And finally, they need to be efficient. They've got to be able to work quickly and under pressure, organise their time effectively and produce clear, reasoned judgments quickly, and an ability to work constructively with others, so both in a leadership capacity and in a teamwork capacity. So there is a lot of key characteristics and some very difficult things to be able to achieve in order to be a good judge. So my question is, you've seen how people are selected as judges, and you've seen the 5 key areas that judges need to have in order to be selected as a judge. So would you make a good judge? So let's have a look now at the composition of the bench. So starting first with women. So there is only a small number of women on the judiciary, but it has improved since 1990. The first female judge of the Queen's Bench Division was appointed in 1992, and the first woman in the Chancery Division, which is Lady Hale. They were known as the Lords until the Courts Act 2003, and now they're known as ladies, which makes sense, I suppose. And the second woman was appointed in 1999, and the third in 2000. Lady Hale was appointed in 2004 and is the only female Supreme Court judge. In 2007, only 10 out of 100 judges were female, so 10%. And in 2007, 12% of circuit judges and 15% of recorders were female. So think about people from ethnic minorities. In 2004, the first ethnic minority judge was appointed to the High Court. And lower down, ethnic minorities are still poorly represented. In 2007, only 1.5% of circuit judges and 4% of recorders were from an ethnic minority. So the situation even worse than it is with females. And looking at education and social background, higher level judges tend to come from the upper levels of society. And many have been educated at public schools. Nearly all of them have attended either Oxford or Cambridge. Judges spend 20 years as a barrister and mixing with like-minded people, and they are quite often seen as being out of touch with society. So, for example, a judge called an 8-year-old rape victim no angel, which somebody who maybe was more in touch with society wouldn't have said. So let's have a look at the training, because in some respects the training can deal with judges being out of touch. So it's carried out by the Judicial Studies Board, and they receive little formal training. And it's focused on the lower end of the judicial scale. It's aimed at recorders, the idea being if you get it right with recorders, then you'll get it right going further up. Once a lawyer has been appointed as a recorder, they begin their training and they go on a 1-week residential course. Then they shadow an experienced judge for a week, and then they sit to hear cases. Usually 1-day courses are available from time to time, especially on the effect of new legislation. The training is very short, and it may not be, so a new judge may not be very competent. Some recorders may not have practiced as lawyers in criminal courts, so their expertise is quite limited. So there is no compulsory training for High Court judges, but they are entitled and invited to go on these courses. 20 years ago, training would have been insulting, but now it's seen as accepted and a way to ensure that you are keeping up with any changes. There's also human awareness training. In 1993, the Racial Awareness Training course was introduced as recommended by the Judicial Studies Board and was accepted by the Lord Chancellor. All circuit judges and recorders must attend a course designed to make them aware of what might be unintentionally discriminatory or offensive. So, for example, saying to somebody, "What is your Christian name?" rather than saying, "What is your first name?" may not be done intentionally, but it could be offensive. And refresher courses and seminars are available. So, for example, so the next thing that I'd like you to have a think about is around what's known as judicial tenure, or how to dismiss a judge. I'd like you to have a think about these two questions as we go through. These are questions for you. Why is it seen to be important that judges are secure in their positions? And do you think it's too difficult to dismiss a judge? So retirement. So judges retire at 70, and this was decided in the Judicial Pensions and Retirement Act 1993. Some judges are allowed to continue after this, and prior to this all judges could sit until the age of 75, but it's been reduced to 70. So looking at the tenure of superior judges cannot be dismissed by the government, and they're very hard to dismiss as they are protected by the Act of Settlement 1701, which says that a superior judge can hold office whilst of good behaviour. They can only be removed by a petition to the Queen presented by both Houses of Parliament, and it's only ever happened once before. This gives superior judges protection from political pressure and allows them to remain independent. And the one time that it happened was in 1830. Sir Jonah Barrington misappropriated £700 paid to the Admiralty Court of Ireland. He fled to France and was dismissed after an address which was presented to the Crown Court by Parliament. The Lord Chancellor can, after consulting with superior judges, declare vacant the office of any judge who, usually through ill health, is incapable of carrying out his work and of making decisions. This was introduced by the Administrative of Justice Act 1973 and is also in the Supreme Court Act 1981. So it is extremely difficult to remove a superior judge unless it's on health grounds. Inferior judges can be dismissed by the Lord Chancellor for incapacity or misbehaviour under the Courts Act 1971, and this can include criminal convictions for dishonesty. This is used very sparingly, but Judge Bruce Campbell was dismissed in 1983 for smuggling substantial amounts of cigarettes and whisky into the country on his private yacht. So that's the sort of level of misbehaviour that we're talking about. The Constitutional Reform Act 2005 sets out that the Lord Chancellor must now follow a set of procedures to do this, to dismiss somebody. And it also says that the Lord Chief Justice has the power to suspend a person from judicial office if they've been convicted. This can only be done by following So let's now have a think about the separation of powers. So the theory of the separation of powers stresses the independence of the judiciary, a big part of the reason why it's so difficult to remove them. and they've got to be independent from the executive and legislative branches of the government, and they have to be non-political. UK judges interpret the meaning of the law and enforce the law, but they don't make the law or overturn it. Past legal decisions set a precedent that is there to guide judges in making their decisions, and law that has been shaped by judges in this way is known as common law, as opposed to laws passed by Parliament, which is statute law. So it's really important that judges are independent from politics. They're not allowed to be members of the House of Commons or any other elected assemblies like the Welsh assemblies. The Law Lords did sit in the House of Lords, but by convention they didn't take part in political debates. And the Constitutional Reform Act 2005 set up the new Supreme Court as the final court of appeal, and it's physically separate from Parliament, and judges do not have the right to sit in Parliament or in the House of Lords now. Independence from the government. The superior judges can't be dismissed by the government, but it could be said that their appointment is not independent, as the Lord Chancellor is involved in the appointment of judges. However, judicial independence is now guaranteed under the Constitutional Reform Act 2005, and this states that the Lord Chancellor, other ministers in government, and anyone with responsibility for matters relating to the judiciary must uphold the continued independence of the judiciary. This section also states that the Lord Chancellor and other ministers must not seek to influence particular judicial decisions. And finally, freedom from pressure. So judges have immunity